When actor Chadwick Boseman passed away, he left behind a massive legacy. People often assume that wealth and fame automatically come with an invisible shield protecting a person's family and assets from the legal system. Boseman left behind an estate valued at $2.3 million. But because he died without a will, his family endured a 2-year court battle. Over $1.5 million of that wealth was drained away by lawyers and court fees. This is a common trap. Today, 85% of Americans are making the exact same mistake by operating without a valid estate plan. Skipping this paperwork means you are voluntarily handing your hard-earned assets over to the court system. That system is called Probate Court. It is the mandatory, default legal process where a judge steps in to take control of your asset distribution if you die or become incapacitated without a plan. The moment you enter probate, your personal assets are locked tight by the courts for a minimum of 2 years. While your family waits, court and legal fees actively drain anywhere from 10 to 50% of your estate's total value. For business owners, that 2-year lockup is lethal. 76% of businesses go bankrupt during probate because the owner's frozen accounts prevent anyone from paying employees or vendors. Bypassing probate court is the single most critical financial step you can take to ensure your dependents are cared for and your business survives. Building a legal safety net requires a specific 5-document package, and the first few documents actually have nothing to do with passing away. These living documents activate if you are still alive but become legally incapacitated, perhaps suddenly by a coma or a severe car accident. Many people assume their spouse or parents can automatically step in to handle things. By law, they cannot access your medical records or bank accounts without written authorization. That authorization starts with 2 documents. First, a HIPAA release, which is a form allowing doctors to legally share your confidential health data. Second, an advanced medical directive, which designates exactly who has the authority to make life or death medical choices on your behalf. Next, you need a durable financial power of attorney. This document gives a designated proxy the legal right to pay your mortgage, manage your bank accounts, and sign business contracts while you cannot. Together, these 3 specific living documents form a defensive shield. They ensure that a physical medical emergency remains a medical emergency, rather than triggering an immediate financial collapse. For documents used after you pass away, almost everyone has heard of a will. A will is vital for one specific reason. It is the only legal document where you can designate guardians for your minor children. Looking at this flowchart, we see its hidden limitation. A will doesn't keep you out of probate court. It's just a letter a judge must process. Watch the chart shift. A living trust creates a legal bypass, moving assets directly to beneficiaries without delays. A trust also allows for controlled distribution. Instead of handing an 18-year-old a massive lump sum of cash, the trust can stagger payouts specifically for college tuition or a down payment on a house. If you own a company with partners, you require 2 extra tools to complete your safety net: a buy-sell agreement to legally dictate how a buyout happens, and key person life insurance to instantly fund that buyout if a partner passes away. A simple will only outlines your hopes. Only a properly funded trust has the legal power to execute those hopes privately, cleanly, and quickly. To measure the true cost of inaction, consider a recent case study involving a family where a sister, mother, and father all passed away over a very short period. Because they had no legal plan in place, the tragedies compounded. The children's bank accounts were frozen until they turned 18, the courts had to step in to mandate guardianships, and the family home was forced through the probate process twice. This comparison chart reveals the final math. Losses to probate and legal fees surpassed $303,000. With a trust, their total cost would have been roughly $600 in minor recording fees. Estate planning secures a massive return on investment. It establishes an impenetrable legal firewall around your family and your life's work. Do not wait for a crisis to build this safety net. Take the time now to set up your documents or review your existing plans to ensure your beneficiaries are up to date. Reach out to In The Greene Financial for a complimentary 30-minute consultation. Visit inthegreenbooks.com/financial or call 844-573-3846 to secure your legacy today.